this. Oh, yes, thank you. These sort of trainings are one of the complements that we offer to our nonprofit partners. We are recording today, as you just saw. We will be able to share this out on our YouTube channel after today's session. If you find it particularly useful, we encourage you to share it with other people. And I've got our nonprofit support page on the screen there so that you can reach out to our team if you have any questions. But let me introduce who we have with us today. We have Donna Miracle, the Chief Operating Officer of the HR Strategy Group, and Louise Gusson, Executive HR Consultant. And as you can see on the screen, both of our presenters today are credentialed and experienced in human resources management, which is something that many of us are, hoping to be more experienced at ourselves. And so you're probably here today because you're seeking to, get more information in human resources management or be more involved in that scope of work within your own organization. So I want to thank Donna and Louise for being with us today. And I will be on today, but most of the presentation will be with Donna and Louise. So I'll be monitoring chat. And if anything comes up that you would like to ask about, we do have some points during the session today where we'll ask you directly for questions, but you can also feel free to type in chat and I'll be monitoring that. So I'm going to go ahead and mute and hand this over to Donna and Louise. Thank you.
Wonderful. Thank you for the warm welcome, Heather. We really appreciate it. Just a little disclaimer here because the lawyers tell us we have to do this. Today's webinar is being recorded. We mentioned that already. The materials presented in this webinar are for informational purposes only and not for the purpose of providing legal advice. You should contact your HR consultant or employment attorney to obtain advice with respect to any particular issue or problem. Participation in this webinar does not create a client relationship between the participant and HR strategy group. These opinions expressed in the webinar are the opinions of the presenters and may not reflect the opinions of other HR or legal professionals. Whew. We'll get all that technical stuff out of the way and we'll get into the meat of things. In today's webinar, what we intend to bring you information about are the changes to Maryland's minimum wage, new information about the implementation of Maryland Paid Family and Medical Leave Program, Maryland's non-compete agreement provisions, the federal non-compete agreement proposal, so much going on in that space. Maryland Attorney General's enforcement of discrimination provisions, and of course, what may be becoming more and more prevalent of an issue or a concern, Maryland's recreational cannabis and the workplace. Please feel free, if you have questions, as Heather mentioned, put them in the chat. We may address it, in the webinar, but if not, we're happy to answer that. If you have questions that are more personal to the end, you'd like to, we will stick around for a few moments and help you there. So let's jump in to our presentation talking about Maryland's minimum wage changes. If you advance it, Louise. Maryland's current minimum wage is $13.25 for employers with 15 or more employees. With less than 15 employees, minimum wage is $12.85. However, effective January 1st, right around the corner, coming up faster than we'd like. Effective January 1st, 2024, $15 per hour will be the minimum wage, regardless of the number of employees. So it'll be for all employers, no exceptions. If you'll advance first, Louise. So what do we need to do about this? What do we need to be looking at? First and foremost, please take the time now to take a look at the pay rates of all of your employees. Understand how this may impact you and what you need to be doing to get ready. When I say all employees, I really do mean all employees. Don't forget your salaried employees, though frequently our salaried employees are paid at a higher level than this. Be sure that if you do have any non-exempt salaried employees that you're paying, that their biweekly pay is at least $1,200 and their semi-monthly is at least $1,300, depending on your your pay schedule. Remember, for someone to be exempt, they must earn at least $684 per week and meet one of the tests as part of the Fair Labor Standards Act. So I throw that out there because sometimes we get a little confused about, oh, well, I'm paying someone's salary. I don't have to pay them overtime. There are a couple rules involved with that. Not that that's what we're about today, but I'm a big proponent. I always throw it in there any chance I get. Make sure we're paying people properly. And then the next thing is to make sure that we're taking a look at any internal equity issues that may be coming up because of this. Do you have people who are really close to the minimum wage that you feel that, you know, this is going to impact them? Or is there any wage compression happening because of this? Do you need to take a look at that? Again, this is the time to be looking at all of that, especially for those that need to do some budget planning. Better to be prepared for this ahead of time versus waiting until, you know, December 31st when, oh my gosh, I've got to get folks bumped up to this level by tomorrow. And then prepare for those rate increases. I think I've already just said this about 1,000 times, but 1/1/2024, anyone working from that period on, minimum wage, $15 an hour. So they must be at that level. Any questions at this point? I feel like I ran through that a little bit quickly, but the really big point of this is that this rate increase is effective 1/1/2024. There, you know, no exceptions for employer size. Okay. All right. If you think of something as we go along, feel free to put it in the chat. We can address it later on. But we'll go ahead and we're going to move on to our paid family and medical leave, PFML. So some people are just hearing about this for the first time. Others have been following it. It's been in the news. I'll be really honest with you. This has not been in the news as much as I would have thought it would be. But here's a brief timeline. Back in April 2022, the Time to Care Act passes. It was signed into legislation. May of 2023, we were supposed to have had some things happening come this October, but they made a decision to modify the bill and put some delays in place because we just weren't ready. What we will see is this October, the rates for paid family medical leave will be set. We have some idea of what that might look like right now. January 2024, the regulations will be finalized. And that's really what all of us as HR professionals and you as organization leaders are waiting for, because until we have that, we really don't know exactly how this is going to impact us, what we're going to have to do. But what we do know is that October 2024, we're going to have to start withholding payroll withholdings from our employees and potentially making contributions ourselves. And then come January 2026, employees will be able to start requesting benefits being paid to them. So you're probably sitting here saying, Donna, what does all of this mean? I'm not really sure what's going on here. So we're going to take a little step through. Louisa, if you'll advance for us. So what does this mean? This is paid family medical leave that the employee and employer will share in the cost of this leave. Employees will be eligible to take 12 weeks of paid leave for FMLA type reasons. They may be eligible for additional 12 weeks for parental bonding. There's just some things that will add additional time to that. The leave, just like FMLA, can be taken intermittently. The pay benefit is going to range from between $50 and $1,000, depending on how much that individual earns. They will be eligible to continue their health coverage through your agency, organization, or company. And this also comes with job protection. So just like FMLA has job protection, this paid benefit will also include job protection as well. So unless they're being terminated for cause, or the reinstatement will cause substantial grievous economic injury to the operations of the employer, which I will tell you, the courts have found that to be very, very, very narrow. It has to be very, as it says, substantial and grievous. So I wouldn't count on that piece being the case for most of us. And we must notify the employer of the denial of reinstatement at the time the determination is made, not just when they return. So what can we expect from all of this? The Maryland Department of Labor is going to issue regulations on or about 1/1/2024. When they do, we will have much, much more information about how this is going to be administered, what the role of employers are going to be, what role employees will have to take in both requesting and receiving benefits. Contributions will begin being collected, both the employee and employer. Remember, I mentioned this is going to be a 50-50 split between employers and employees. That will begin on 10/1/2024. And then employees will be able to begin using this benefit on 1/1/2026. So this is what we know as of right now. So we're going to just put a big stay tuned. We will absolutely be offering another webinar about this topic and this topic only sometime in early 2024, once the regulations are out and we've had time to dissect them and funnel them down into usable bites that you can that we can give to you. Louise, if you'll move us along. What else you need to know? The contributions, some people are kind of panicking saying, well, wait, what do you mean we're going to have to start paying money into this? What does this mean? Well, what this means is that and this is part of the modification that happened just this past May, is that the total contribution rate will be capped at 1.2% of wages up to the Social Security wage base. So what this means is that as an employer, the most that you would be expected to contribute would be 0.6% of each employee's earnings up to the Social Security wage base. The Maryland DOL expects the contribution rate, and this is something they've kind of thrown out there. It's not official yet, but it is something that has been thrown out there, and that is that they anticipate year one contributions to be between 0.8 and 0.9%. So for employers, that would be 0.4% to 0.45%, same for the employee. The Maryland Department of Labor Secretary will set the rate each year. This will not be based like unemployment, where it depends on your experience rate, how much you use it, how much your employees use it, how much they don't use it. It's going to be flat across the board, the same for every employer in Maryland. I mentioned the 50-50 split. Did I covered all that? There are a couple of exemptions, and that is, exemptions from or limitations on employer contribution. And that is with employers with 15 or fewer employees. The employees will still need to make the contribution. The employer may not be required to make the full contribution. Again, that's something that's still being fleshed out. We'll know more come the first of the year. And then programs that serve individuals with mental disorders, substance-related disorders, or developmental disabilities. Those nonprofits, those programs, they will not be required to submit the employer portion of the contribution. However, employees will always still need to contribute in. So all size employers, all Maryland employees are eligible, regardless of the employer size. We had some questions in the past about, okay, well, we're a Maryland organization, but I have some people who work in Delaware. Maybe they work remotely, maybe you have an office in Delaware. those employees would not be included. They work in Delaware. It's only employees that work in Maryland. Okay. All right, moving on along. So our friends in DC went through this now. I want to say it's been about 3 years now, and it's moving along quite nicely for them. They worked out, they were able to iron out the wrinkles. So I'm hopeful that our friends at the Department of Labor, Maryland Department of Labor, are going to take some lessons learned from them. One of the things that we learned working with our clients in the DC region was that short-term disability plans did not provide they did not provide additional benefit to employees. So if employees were receiving the paid family leave benefit from DC, they basically were just not getting any benefit from the short-term disability. So this is a concern for any of you that may have short-term disability plans. We'll talk about that in a few minutes, but again, it's just something that we learned from there. And then the other thing that we learned was that employers were expected to provide the majority of the information and training to employees. And so, that really became a little bit of a burden to employers. There was a lot we had to do in terms of obviously putting up posters and things like that. Posters now can be a little bit challenging because a lot of us have remote workplaces. We needed to do handbook updates. We also, needed to educate people as they were having leave situations where maybe they were going out to have a baby, or maybe they were, having paternal leave or spousal leave. We'll just call it spousal leave, partner leave, whatever it might be. And so those are some things where, we as employers were really expected to be the experts in that. So it does make a difference. Okay, Louise, so you forward us on. So what do you need to do right now? First and foremost, don't panic. There's not a whole lot you need to do at the moment. What we need to do is educate ourselves, and that's exactly why you're here today. This is a great first step. Educate yourself, educate your team, get ready for early next year when we're going to have a lot more information. The next piece is to take a look at your short-term disability policies. If you're renewing your plans anytime in the near future, talk with your broker, talk with your short-term disability plan provider, and ask them how they're planning to provide benefit. Now, remember, employees in Maryland are not going to see this benefit until 2026. So we've got some time, but you may just want to be thinking about that as you move it forward. And then the third piece is watch out for our newsletters and webinar updates. January 2024, or as soon as the Maryland Department of Labor issues their regulations, we're going to have information out to you as quickly as we can. And so, we're going to make sure you're as informed as you need to be and ready to go, as things are happening. So, questions about the paid family leave, family medical leave, or no? Okay, I feel like I've stunned everybody to silence. So either I've been doing this enough now that I'm answering questions as I go, or or people are stunned into silence. So we'll go with I'm answering questions as we go. All right, you're stunned. Oh gosh, I'm so sorry. So sorry to hear that. All right, well, we will get through this. Just like with everything else, we will get through it, and we will be here to help you along the way. All right, Louise, let's go ahead and we'll move us on to our non-compete bans. This is something that I'm not sure a lot of you are going to have in your repertoire of things that you're using with your employees, but it's important to be aware of it. So we're going to take a quick jaunt through here. The first thing is that the non-competes in Maryland or I should say non-competes in general throughout the course of the US are really facing a lot of scrutiny, and they're being banned. Broad non-competes are really taking a hit and being banned in many states. And Louise is going to talk in a few minutes about the federal proposed ban as well. Basically, in Maryland, since 2019, anyone who had a compensation of less than of $15 an hour or less, equivalent of 31,200 or less annually, you could not include a non-compete or conflict of interest provision in an employment contract. So employment contract can include offer letters. It can include a separate non-compete agreement. So it's really something to be aware of. You may want to review, I'm jumping ahead, but effective 2024, employers will be prohibited from including non-compete or conflict of interest provisions in an employment contract for an employee who's making the equivalent of 46,800 or 22.50 an hour. So again, you're going to want to make sure you're looking at your offer letters and any additional non-compete agreements you may have. They can also, if you've got a non-disclosure confidentiality, you might want to just be reviewing that to be sure that you aren't inadvertently putting some kind of non-compete piece in there. And I think I probably jumped ahead a slide, but Louise, if you'll move us along. So what are the things that you need to do? We're always big on giving you steps. What do you need to do? Take a look at those documents. Take a look at your offer letters. Take a look at any separate documents you may have, especially non-competes, non-disclosures, even some of your confidentiality agreements. You might want to just double check and make sure that you are not requiring someone under those thresholds to sign those documents that have conflict of interest or non-compete clauses to them. You can still retain confidentiality agreements, and I do encourage you to be sure you have those in place in your offer letters, in your handbooks, and in separate agreements if necessary. You can certainly ask us to review those or review with your attorney, but they are still legal and encouraged. And then review your client lists and proprietary information, update any agreements and policies that might prohibit your employee from talking with clients, that are that have client, taking a client list, things of that nature that can weigh into those non-compete pieces as well. So we just need to take a look at those. And then if you've got someone who is a high-risk employee, consider wage adjustments to get them over those thresholds, so that you can then offer them, put in place an agreement that has the non-compete piece to it. Again, we don't see a whole lot of this with our nonprofit clients, so I'm not sure how applicable this may be to you all. However, it is just important to know because sometimes we do things inadvertently. And so we just want to make sure that everyone is keeping themselves on the right side of these new laws that have been put in place. All right, Louise, anything move us along?
Donna, there is a question in chat about paid family medical leave. I don't know if you want to handle that now.
Oh, sure. If you guys are okay with that, I will go ahead. Okay, so the question is, how does PFMLA affect Maryland residents that work for a company in another state? Are they still covered? So the answer to that is yes. All employees that work in Maryland, regardless of where their employer is based, will be covered by this law. This is for all employees that work in Maryland. They do not have to reside in Maryland. They have to work in Maryland. Will our Delaware companies with employees in Maryland be paying this tax? Yes, they will be. Only for those Maryland employees. So let's just say that you have, I'm going to use round numbers because I can't do math otherwise, but let's just say you've got 100 or you've got 30 employees. 10 of them are in Maryland, 20 of them are in Delaware. You're a Delaware company. You would only pay this this tax on your employees working in Maryland. So I hope that clears that up. If there are any other questions about that, then please just let us know. Okay.
Donna, we had a question from another session that
Uh-huh.
said, what if I'm a Maryland employer with out-of-state teleworkers that work at the Maryland location a couple of times a week and then work a few times a week at home? Do we have any idea what would happen with paid family leave in that situation?
So we do not have, so this is going to be what we know right now is that we don't know for sure. What we think we are going to find is that just like you would have a worked in state, for those of you who handle payroll or who handle unemployment, what you do when you have employees like that is you select a worked in state for them, meaning they spend the majority of their time working in a certain state. And that's the state that you pay unemployment tax on them for. You would do the same. We're expecting the same thing to be happening with this paid family leave as well. So if someone is working the majority of their time in Pennsylvania as a teleworker, but comes to Maryland 1 day a week or once or twice a month for meetings or so forth, they would not be considered to be a Maryland employee. So again, we will get much more guidance about this come January. We hope by January we'll have that detailed of information. Some of this may come about as we get closer to them actually collecting the fees, but as of right now, that is sort of what we're crystal balling. But if they do not work in Maryland for the majority of their time, you can pretty much guarantee they're not going to do a percentage based. It's kind of all or nothing.
Thanks, Donna.
Thank you.
All right.
Thank you.
All right. So we'll move on to the next topic. This is the FTC's proposed rule regarding non-competes. And what Donna talked about with Maryland, I consider that the chisel, right? It's just chiseling away at what you could do with a non-compete. The FTC proposed ruling is the sledgehammer, okay? So this would be big because what FTC is saying, we don't want any non-competes. They're proposing a near total ban on non-competes as of April 2024. And they're looking at what all the states look at. Does the provision have a non-competitive effect? Because what the government is looking at is, are we preventing employees from working someplace else? And what Donna said is you may not have any of these agreements or very few of these agreements, and be careful even to look at your CEO or president contracts because sometimes those clauses are embedded somewhere in the 97 pages in the fine print. So you want to make sure that you have legal counsel look at that to see if they happen to be embedded there. And it would make this proposed ban would make it illegal to enter into any kind of non-compete provision. This has been kind of quiet, but if it goes through, this is huge. So it would force employers to rescind existing provisions. So it rescind any of the non-compete bans that happen to exist. So exceptions, well, there is only one exception, and that is for an owner in connection with the sale of a business. And you see that frequently if someone sells a business and new owners take over, which you wouldn't have in nonprofit world. That would be an exception where they say, well, we don't want this former owner selling us the business and then taking it away again. We expect legal challenges. So, as we keep saying, stay tuned, right? But there's only one exception, and that is this one. So what should you do now? Be alert. You're attending this session here, which is the first good step. Know how this could impact your organization. So, again, you're going to be looking at any kind of agreement that you might have out there, whether it's explicit or hiding somewhere. So you're going to be doing basically the same analysis that Donna suggested for Maryland. And you want to just audit your non-competes again now to prepare if you do have them. And you want to make sure you're notifying, if you are the executive team, notify the board. If you're not part of the executive team, then notifying the executive team just to let them know that these two particular changes are out there. May not be a huge deal, but you just need to look at them. So speaking of sledgehammers, This one is big. So Maryland decided recently that the legislature said, we want the Maryland Attorney General now to have the authority to investigate, prosecute, and sue employers for violations of state anti-discrimination laws. And remember, these are very pretty comprehensive laws as far as race, sex, etc. So it's really important. This is something that affects all of you, and it's something that you want it not to affect. So it's very important. So there's 3 years. 3 years is the magic number here, the magic horrible number that the Attorney General has to commence an action. Right now, under EEOC and local EEOC agencies, the guidelines say that an employee has 300 days to initiate an action based on discrimination. This is tripling the amount of time that can lapse between the time that something happens, that a claim arises, and the Attorney General can actually sue. So this is huge. Another horrible provision about this new law is that there are several ways that the employee can get relief, and every time an employee gets some kind of relief under something like this, you are impacted. So there could be injunctive relief, meaning that the employer is required to do something or stop doing something. And that goes hand in hand with equitable relief. Then economic damages. So the Attorney General could determine an unlimited number of dollars in economic damages. The other horrible thing about this is that the Attorney General can also impose civil penalties. They range from $10,000 to $25,000. The last horrible, I mean, if you're not getting the idea that this is horrible, the last bullet point, the state can assess the cost of the state's investigation and litigation. So you could end up paying the economic damages that the employee claims that the Attorney General approves, the civil penalties the Attorney General imposes, and also whatever costs the Attorney General says are attributed to the investigation and the litigation. We don't have any idea of what that could be, if there may be any limits. As with a lot of these new laws, we expect legal challenges. So the most important thing is you don't want to be part of the loop of understanding these legal challenges. You do not want to be involved in anything having to do with an Attorney General action here. So we're going to talk about what you can do and what you can do now. So prevention is the key. So first, know the impact on your business. So take a look back at that horrible slide, the doomsday slide about how it can impact your organization. Plan harassment prevention and discrimination case training. Now, nothing is ironclad, of course, but what we understand in Maryland and in some other states where training is not required. So Maryland does not require sexual harassment, discrimination, respectful workplace training. But if you have regular training, it could maybe help because you've taken steps to try to prevent what has happened. You can't be everywhere. You can't 100% prevent something, but prevention is absolutely essential. Donna's going to talk a little bit later. We do offer respectful workplace training, and that is our prevention training, prevention for discrimination based on all of those protected categories. Also, equally important, address problems when they occur. One of the worst situations an employer wants to be in, first of all, having a complaint filed and having the Attorney General on your doorstep is not a good thing. What can make it really a lot worse is if problems occur and whoever's investigating this complaint sees that nothing was done. So it's very important to know what's going on in your organization, address those problems. Do not allow managers to sweep things under the carpet. They have to be addressed head on. And that is something that we cover in our respectful workplace training. So we do a session for staff and we also do a session for managers. It's very important because the managers in your organization are your eyes and your ears, right? How better to know what's going on is to have the managers out there, whether it's, in your workforce, on the floor, if you put people in the field, wherever it is, making sure that that information is forthcoming. So make sure that you ask us for help if you need help in that regard. Any questions about this particular sledgehammer?
I promise we're not fear mongers. I feel like today we've given you a lot to be wary of, but really we do this because you need to be aware, and we want to make sure you have the tools to prepare yourself for what's coming or what's come already.
Yeah. Yeah. And, having the training and talking through some of these problems with an HR expert, we find that clients actually get a little bit more calm about what's going on and less fearing the unknown. So let us know if we can help with training. All right. So our last topic is recreational cannabis in the workplace. So the voters have spoken, right? I'm sure everybody knows that recreational cannabis was legalized in November of 2022. When we were talking with Heather before the webinar started, Heather, you gave us some astounding sales figures of what the industry is yielding at this point.
Yeah, I had just gotten a message. I'm signed up in the Maryland Chamber of Commerce's newsletter, and they had every Friday they share the Friday top 5. And on last Friday's top 5, they shared that over $87.43 million was spent on cannabis in July, which netted the state $4.61 million in sales and use tax, which I thought was astounding.
Yeah, thank you, Heather. So there's a lot of people in Maryland spending a lot of money on recreational cannabis. So what does that mean to you? So, from a practical standpoint, it means there's a lot more people that are using cannabis, right? That's what it sounds like, which means that your workforce use of cannabis could possibly increase. So the good news is, well, there's a lot of good news with this. As of January 1, 2024, the Clean Indoor Air Act will be amended to include prohibition of marijuana or hemp products in any indoor place of employment. So, that's common sense, right? Most employers, know that people should not be smoking in the workplace or not permitted to smoke in the workplace, but now this smoking or vaping includes cannabis products. Now, as far as a workplace impact, we do have the practical impact of, is there a chance that people could come to work under the influence? Yes, statistically speaking, right? If you have more people using recreational cannabis. But there's no provision in the law that changes what you can do about people being under the influence or using cannabis in the workplace. So we're actually ending on a positive note, right, Donna? Like this law is not so bad, right? And it, a quote is, Maryland law does not prevent an employer from testing for use of cannabis for any reason or taking action against an employee who tests positive for the use of cannabis for any reason. Now, this prohibition, or this allowance, I should say, of testing for use, et cetera, not been tested in the court. So we don't know exactly what's going to happen, but you can still do testing. Now, some employers are backing away from testing for cannabis because it's just everywhere, right? There's medical use and now recreational use in Maryland. Just be careful that you're looking at any grant documents that you may have or other funding documents, because it may say you have to test. So before you decide to back down, if you're thinking about backing down on your testing right now for cannabis.
Louise, one of the other things that came up in one of our other sessions was that remembering too that testing for cannabis has not necessarily caught up with this law. And so cannabis stays in your system for much longer than when the person may be what we would consider to be high or, under the influence of cannabis. And so it's really, until that testing really gets to the point where it is a little bit more sensitive to, to that, then I think that's where we may start seeing some of this testing in the courts. But you, of course, can still do that. I just want everyone to kind of be aware that just because someone tests positive for cannabis doesn't mean that they were under the influence of it in that moment you were in the workplace. So you want to be using all of your other tools when deciding if someone might be under the influence, what's the appearance, their work performance, accidents, and so forth. So just kind of throwing those things out there.
Right, right. And Heather just put in the chat that federal grant funders will likely require testing at this point. So it may be a moot point to pull back on testing, but yeah, Donna has a good point, and it all goes around performance. I mean, there's nothing that says you cannot do reasonable suspicion analysis if someone is impaired, because no matter what people are allowed to do with cannabis, they have to come to work ready to work and able to perform the job and not under the influence. And especially if you have people who are driving on behalf of your organization, that's really important. So, so what do you need to do now? Again, stay tuned. We just want to make sure you have this on your radar screen. There may be some ruling or some court cases or regulations about employment discrimination based on medical or recreational use. We're just not sure. And there may be some restrictions on pre-employment testing. But as Donna said, if they're going to do pre-employment testing, if you don't need it for federal funders, what does that really mean? It doesn't say anything as to performance, or it may not. Review your employee handbook. Make sure your drug-free workplace policies are up to date. If you have questions about whether this legislation and proposed effects and future steps how they might play out as far as your policy is concerned, we can help with that. And the most important thing, and this is where I say we're ending on a positive note, right? As we said a few times, you can continue to prohibit possession, use, or being under the influence at work. There's nothing stopping that. So any questions about the recreational cannabis? Okay. Donna, back to you.
Absolutely. Absolutely. So thank you all for being here with us today. We will, as I mentioned, stick around. We have a few slides just to go over with you. We're here to help. You can always schedule a consultation with us. Start doing your auditing of some of the things that we talked about today for your minimum wage, for any of your agreements that you might have with your employees to check out for non-compete provisions. More webinars will be coming. We will be sure to let Heather and her team know about them so that we can get them out to you. We would be happy to have you join us. We do have a newsletter, and we would be happy to have any of you who would like to join. If you contact either Louise or I, Heather was just so kind to put our emails into the chat. Thank you, Heather, for that. And stay in touch and consider training for both your your employees as well as your managers. Louise, did you just see that there was a question that came up? But I will move into just briefly letting you know, Louise mentioned this. We do offer customized respectful workplace training that we can bring to your workplace, either virtually or in person. We address prevention of harassment, discrimination, and bullying in the workplace, which has become a big hotspot lately, through the lens of a respectful workplace. And your values. The most important thing is really doing that through your values. We make it very interactive. We want it to be fun. We don't want people just sitting there. We want to engage everyone. We want people to come away with tools to use to be able to go out into the workforce, and if they see things happening, to be able to do things.
Donna?
Yes.
I wanted to address this question. So Wayne had mentioned, I think the new law simply empowers the AG to sue on behalf of employees, that the employees can already sue employers within a 3-year statute of limitations. So that's correct. So employees, yes, can file direct actions. They can file EEOC type complaints, but this new law just adds an extra layer that allows the Attorney General to appear on your doorstep and pursue an action with the additional civil penalties and the cost of the investigation and the litigation. So there's a lot of different angles that can be huge sledgehammers for respectful workplace claims and discrimination claims.
Yeah, absolutely.
Thank you, Wayne.
Thank you for that clarity.
Yeah, absolutely. So respectful workplace training, again, this is the first arrow in your quiver to protect yourself and your organization, by letting everyone know what discrimination is, discrimination is never acceptable, but what behaviors are acceptable in the workplace, what's not acceptable in the workplace, and to train your managers to be on the lookout and for them to know what to do when these things happen. So many times managers just don't know what to do, and so they do nothing. And that's the worst thing that can happen for your organization. So again, call us or email, and we're happy to talk with you about what we could do for your team's development there. Louise, if you'll move us on. The other thing is, and this is new, and Heather and I have been working on something together. We're looking in October to create a date we'll be putting something out for an October date to do what we call our 3-10-90 management masterclass. In 3 hours, we'll discuss 10 things that you need to do in the next 90 days as a manager in your organization to up your leadership game. And so this is something we're very excited about. We're getting great feedback from our clients. So many times as managers, we just don't always have all the tools we need. And so that's what we're really providing for you in this session. So we're hoping to see a lot of you there. Again, Heather's going to be putting out some blasts, I think, in the next week or so for a date in October. And we hope to see some of you there. And then last but not least, Louise, we have one more. We did this already, I think. So again, we just want to thank you for letting us be in front of you for this last almost hour. We're going to stick around for the next few minutes. If you've got some questions you want to ask us on a more one-on-one basis, we're happy to stay to do that. Thank you again. Thank you for investing your time into your organization today. We look forward to hopefully seeing you all again.
Thank you so much, Donna and Louise. Please keep HR Strategy Group in mind. As mentioned, I am going to be polling and announcing through our e-newsletter next week what we're working on together for the October timeframe, and maybe you'll be able to join us there as well.
Wonderful.
Hope you enjoyed today's session. We are all going to be here for a few more minutes, as Donna mentioned. And I put our YouTube link at the top of chat. I'm going to drop it in again at the bottom. Next week, I expect we'll be able to load this session into our YouTube channel so that you can share it or look at it again. Thank you, everyone.
Thank you, everyone.
Thank you. Thank you for having us.